Good afternoon, everyone, and welcome to today's webinar, GroupBC, supporting you with GDPR compliance. I'm Gavin O'Neill, Head of Account Management, and I will be acting as your continuity announcer today. Before we get started, I'd like to go over a few items so you know how to participate in today's event. We've taken a screenshot of an example of the attendee interface. You should see something that looks like this on your own computer desktop in the upper right-hand corner. You're listening in using the computer's speaker system by default. If you would prefer to join over the phone, just select telephone in the audio pane and the dial-in information will be displayed. You will have the opportunity to submit text questions to today's presenter by typing your questions into the question pane of the control panel. You may send in your questions at any time during the presentation. We will collect these and address them during the Q&A session at the end of today's presentation. We are joined today by Paula Tai, Partner, Information Management and Governance at Wright Hassel Law Firm, and Peter Brown, GroupBC's Information Security Manager. The objective of this session is to both inform and update our client base with industry expertise and the latest on what GroupBC are doing to meet GDPR requirements. I would like to introduce Paula Tai, Director, as I said, Partner of Information and Governance from Wright Hassel. Wright Hassel was recently voted Best Regional Law Firm at the Lawyer Awards 2017. The Oscars of the legal industry, so we're very grateful for Paula's time and expertise today.
Thank you very much for that introduction. Welcome, ladies and gentlemen, to your GDPR compliance overview. Just to get started, you have 120 calendar days, 9 hours, 58 minutes, and 7 seconds to ensure you are fully compliant with the GDPR, as the implementation date is the 25th of May 2018. Now that we all take a massive deep breath, now I'm going to talk about the reality of can we all achieve full compliance by the 25th of May. 128 calendar days is not a long time, because once you've taken annual leave, sickness, holidays, you've probably got in the region of about 54 days to actually complete the work to ensure compliance. So in Wright Hassel, we've taken a very fair approach to both our services, our clients, but also the GDPR. Because yes, surprisingly, as a legal firm, we also have to be GDPR compliant. So I am the partner of information governance for our clients, but I'm also the director for the GDPR project plan within the firm and the deputy mandatory DPO as of May this year. So what are the key points? What I will be addressing through this webinar today is the overview of the changes that are coming in. The DP bill and how the DP bill will preserve what we are familiar with in some part in the 98 Act, and how it will bring in the General Data Protection Regulation in its entirety. Brexit does not stop this. Regardless of us Brexiting out of the EU, the GDPR will remain. It also, and what we will be talking about in brief, is how the GDPR, the DP bill in the UK, will regulate the processing of people's personal data. The 6 principles of the new data protection bill will be adopted as the 6 principles of the GDPR. The most big change is accountability and the responsibility of each organisation, both the controller who determines the collection and use of people's data and the processor who acts on the instructions of the controller to process that data on their behalf. There are changes in regards to personal data and a further strand of personal data, one what we may not have expected to be there. There is also sensitive data, which is now changed to special categories of data, and again 2 more strands have been added onto that. There's an awful lot of myth around affirmative consent, and I'd like to address that as we move forward. And also the requirement for data processors, third-party suppliers, to have the GDPR compliance embedded into mandatory contact clauses, as well as compliance certificates, and also the demonstration to ensure they are compliant in regards to the products and services they supply. It's harder to process criminal records, but the DP bill has preserved the requirement to process criminal records alongside the law enforcement regulation, and we're looking at that currently. But there will be further codes of practice regarding the sharing of data between public and non-public bodies and the processing of marketing data business to person and business to business. And there's a lot more onerous on us on how we comply with the new laws on cross-border data transfers to ensure that it's fair, lawful and secure. But let's have a little look at what people's rights will look like under the GDPR and under the DP bill in the UK. Well, no surprise. It's all about being clear, open and transparent, and each controller or processor will have to have proper, readable, understandable privacy notices telling people how they will collect, use, share, store, secure and retain their data, and who they will share that data with. So they will have to list how many data processors and who those processors are and what are they doing with the data. We're currently looking and working with the regulator to see if we can hone that down more into a category of processing rather than having to list every single third-party supplier, because our website are going to be very big if we have to list them all and keep them updated. Affirmative consent. There will be a requirement to obtain affirmative consent, but the first thing you need to be doing is looking at your legal gateways. So let's look at HR data. You will have a legal gateway to obtain an employee's data or an applicant's data to process their recruitment, because they are actually giving you data for a purpose. When they are employed, they're signing a contract of employment. You cannot conduct your processing activities or your employer-employee relationship without the performance of a contract. So that's your legal gateway to collect, use, share, store and process data. There's a set of legal gateways to collect personal data and a set of legal gateways to collect sensitive or special categories data in the new law. If you haven't got either one of those, you've got another gateway which is called your data controller's legitimate interest. So you need to list those and ensure they're compliant with the law. The final, if you can't rely on the legal gateway or data controller's legitimate interest, you're going to have to go out and record affirmative consent. Unfortunately, that means if you're holding mailing lists, marketing lists, CRM lists, but you intend to use to marketing purposes, you will have to obtain affirmative consent. So a lot of work is being done on how to do that in a compliant way. And we are looking at that ourselves to actually see if there is a simple process we can put in place. And we're talking with the regulator in regards to that, because under the new law, business-to-business marketing is also requiring affirmative consent. The DMA are actually lobbying the working party in the EU to get that changed. We'll see what happens. The requirement to access people's data, so I have a right to access a copy of my data. If I submit that application verbally, social media or in writing, that data has got to be supplied to me in a format, if processed electronically, supplied to me electronically within 1 month of the request being received. If it is not processed, that is a potential 2% fine. We also need to, as a controller and processor, understand how we're collecting data, the type of data, and the processing activities we're doing with that data to ensure that we're only using the data for the purposes that we informed the individual about, or for the purposes of a compatible activity that that person would not be surprised about. And that's a hard one to get round. Again, I have a right to object to how my data is used, shared, stored, and processed. But as a company, both a controller and a processor will have a privacy statement informing me when I can object and when I cannot. To keep it simple, I cannot go to my employer and say, I want you to destroy all of my former employee data because I'm no longer with you and I left. My employer would have to keep certain sets of data like payroll, pension, expenses, and they would have to keep that for a period of time that is in their retention policy, and they would have to inform me of that. So it's making people clear and understandable what I can object to and what I cannot. This is one that's really got people confused, and hopefully I can sort of demystify these two areas. The right to port data came in under the GDPR, and it will in the UK DP bill. I will have a right to go to an organisation that holds my data and ask them to send it to another organisation. That really was there for utility companies, energy companies, and companies that were processing data to enable me to move from one service to another. But it couldn't be, for example, one organisation saying, well, I'm going to be with my bank, I want to port all of my banking statements to Bank B. Well, no, Bank A will say you can't have your bank statements ported over because that is data that we hold, that we have to retain, and we would have to use that to ensure we've met the requirements that we have under your contract. So in your policy, you need to have a data portability policy which backs up your privacy statement of what people can port and what they cannot. The right to be forgotten. Under the current law, there is something already in the current law under Principle 6. I have a right under the current law for erasure to have my data blocked, removed, redacted, or destroyed if I believe it's inadequate, irrelevant, out of date, or it shouldn't be being held for longer than is necessary. That is exactly what this means today in the new law. But what it also means is I can go to search engine sites or social media sites now and formally request in writing that they remove my social media posts or anything about me on a search engine if I can show it causes me distress or damage. So that's what it means by the right to be forgotten. Again, your data portability, your right to be forgotten, and your data protection policy will address that. Again, I still have the right to complain to the Information Commissioner, and the Information Commissioner is setting up triage help desks and helpline, and they've also instigated their online chat with regards to people contacting them, so you can contact them through their online chat process and ask them any question you like and they will answer you. So they're getting ready as well. But I can also take action against the controller or processor and take them to court if I can demonstrate they've caused me distress. So we are presuming there'll be a lot more class action suits as we move through in the next 2 years. So they're just people's rights. Think back, did you know those? Have you got those in place in your policies and procedures? Have you started to discover, identify, and read up what the DP bill is saying? Currently, the DP bill should have been ratified in October of 2017. It still has not been ratified, and from yesterday, it was on its 37th amendment. So you can see there's a lot more to be done. I wish today I could tell you when it was going to be ratified, but I can't. So I'm watching that with a fine-tooth comb. But these are the key elements. It sets out new standards of protecting data in accordance with the GDPR and will repeal the 98 Act. It will preserve existing tailor exemptions. For example, for those that are a geek like me that loves data protection and can reel it off the top of my head, Section 29 of the Data Protection Act as we stand here today enables organisations to process law enforcement data for the prevention, detection of crime or the rehabilitation of offenders. In GDPR, that got rid of that. It stripped that ability. The DP bill brings that back in. It also brings in a lot of other exemptions, and they will be preserved within UK processing activities. It also enables us to carry out information security reviews and document compliance. For the very first time, it is now a legal requirement for a controller and a processor to document their security regime, have a security strategy, and ensure that they have proper controls in place that are tested and documented on a regular basis. There is also a legal requirement to deliver an awareness program that embeds your controls, your policies, your procedures. So you're going to have to document all those as stage 1. There's a wider scope of unlimited fines in regards to an offence under the bill. That actually brings in the requirement to be able to fine under the GDPR 2% and 4% of an organisation's worldwide turnover. It also brings in the requirement to delete posts and images in case of search engines. That's your right to be forgotten. It also has a right with regards to an offence that if you say something is anonymised or pseudo-anonymised, but that document or that piece of information can be easily linked back to the actual identifiable set that you started with, and you say it's anonymised, then that would be an offence. So I would highly recommend you look at your data analytics, your data processing, your big analytic activities to ensure that you've looked at the anonymisation and pseudonymization requirements under GDPR. Like it is in this law, in 98, they've preserved it into the new law. If you alter records, it would be an offence. Again, pre-tick boxes, you cannot default people into marketing. It's affirmative consent all the way. Again, finally, the GDPR brought in the requirements for children under the age of 16 to obtain parental consent if that child was processing data in some form of social media site, some sort of form of search engine, or, for example, some gaming. The UK DP bill brings that down to the age of 13. But there's another law that's crept in that people have probably missed, and that is the Digital Economy Act that came in force last year. And these are the key items on here. The Digital Economies Act has brought in the requirement that any online IP offences will bring a maximum penalty of 10 years. That's an interesting item because we're not just processing people's data, we would be processing probably commercially sensitive data, information, business information. We may be using different pieces of information that we're obtaining from different sources. You need to ensure that you have your proper intellectual property policy in place and trained out. The Digital Economies Act brought in the Direct Marketing Code, and that's currently being written as we speak. And it brings about the power to the ICO to charge fees. Now, the two bottom ones are the things that most of my clients are really happy under GDPR. The GDPR stripped to the requirement to pay an annual fee to the regulator. So in the UK, that's £35 or £500, depending on the type of company. Unfortunately, the UK law has brought that back in, and you will have to pay a fee. It is apparently going to be coming in force in April of this year, where the UK regulator will issue out guidance on the fee structure. Currently, it is based on your annual worldwide turnover and the volume of people's data you process. I suspect that will be more than £35 and £500 for most companies. It also brought in directors' liability. So again, under the current law, section 55 said that if a director or somebody senior enough purporting to be responsible for the company and the company's processing of DP, CEO, for example, that person could, if that person could have known, should have known, would likely have known a contravention of the law could take place, they could have action taken against them. GDPR stripped that. In the UK Digital Economy Act, it's brought that back in. So I'd highly recommend you look at those key areas and build those into your expected compliance picture. And these are the things that you should have already established and are working towards to hit the 25th of May. 1, have you identified through your compliance audit what sort of policies that you have in place, and are they compliant against the GDPR requirements? Because you will legally be required to record and demonstrate, and if required, publish your governance library. You'll have to map your data. You're going to have to identify every individual you hold data on, and is it personal data or special categories of data, if it's children's data, and what sort of protections and retentions have you put on that information. You're also going to have to look at third-party suppliers, data processors, to ascertain where their data is being held. Now, let's just demystify that. If you're using a third-party supplier to hold your data on your behalf, you are responsible for that data, not the data processor. So you have to do the data mapping. Again, you need to ascertain where your data is held, and if it's held outside the UK or in the EU, you're going to have to ensure that that third-party supplier is compliant under the GDPR. I'll go into that a little more in a minute. Again, we've talked about rights and consent. We've talked about the requirement to record and demonstrate and apply security. Now, one of the elements in the GDPR, it talks about security accreditations. It's an interesting area to go and read, and the GDPR clearly sets that out. It's a really easy read document. But what it also sets out, if you obtain an accreditation and there is a serious contravention of the law, the regulator can request that accrediting body to remove your certification. That has actually caught people unawares, and that's something you need to look at in your security regime. Again, it's about training people. It's not a tick box exercise anymore, ladies and gentlemen. It's got to be engaging, enabling, and empowering to ensure every employee understands their roles, responsibilities, and their accountability from board right down to the operator on the floor. So it's a complete, absolutely a round-robin service. You need to ascertain if you need a mandatory DPO, and if you do, you need to fulfill those conditions, which again we'll talk about in a moment. But you do have an ability to outsource the mandatory DPO or outsource functions on GDPR to an external trusted advisor. So they've left that in within the UK law. But the GDPR, the UK DP law, will affect data processors and data controllers. and you need to define roles, responsibilities and accountabilities within your contracts. You need to ascertain compliance. So a lot of third-party suppliers, let's say GroupBC, as well as their clients, are all exchanging information to demonstrate compliance under GDPR. Again, where's that data being held? Who is the owning responsibility? Have you obtained the consent? Does your third-party supplier know that you've got consent to hold that data, and so forth? So that interaction, that client relationship, very much what I'm seeing with GroupBC and their clients, has become something of a focus. Again, already embedded within GroupBC's approach with their clients as a partnership rather than a supplier-client relationship. What I have done, and you will get a copy of these slides and we'll explain later how you can do that, is added in extra information for enable you to understand how to ascertain if your data is outside the EU, outside the EEA, or it's in the world. Because non-EU member companies who process EU citizens' data are now captured by the law, which means the regulator in that country where that data is being held can take action against a company outside the EEA. That could be a US company, an Indian company. So again, it's ascertaining your territorial scope based on where your data had been put out across your third-party suppliers or within your own infrastructure. So again, I've put some extra slides in here to use as a checklist, which I think from what I've discussed with GroupBC will help you as a little bit of a checklist later on. So we'll skip through these until we've got this area. A key element people have not realised is that if you hold data in another country, i.e. outside the UK, let's say I've outsourced it in Germany, and all of my clients' data, all of my data subject data is in Germany, it'll be the German Information Authority that will take the lead, not the UK. The only time the UK will take the lead is if they've had dealings with the controller or processor before. So you need to map out and identify your supervisory authority. And that's why the mandatory DPO is so important, because a mandatory DPO also needs to be qualified in European law. And this is the reason why. Again, an area people quite haven't understood. Again, governance, controls, policies and procedures and accountability. I thought this would help you look at what you need to do and check that off as a little bit of a checklist. Again, your mandatory DPO. If you're a public body or a government body or local authority, you're captured. You need a mandatory DPO. If you're an organisation that is not fitted into that criteria, but you're processing a volume of data in a regular, systematic way that monitors data subjects on a large scale, and that's also profiling information, you've actually hit criteria 1 to have a mandatory DPO. If you're then processing that data for your core activity, i.e. you need that data, if you can't process that data, then you can't do what you need to do, you've hit criteria 2. Therefore, you need a mandatory DPO. So when you've carried out your GDPR compliance audit, that's one of the key areas that should be on the top of the list when you data map your data. The DPO has to report to the most senior person in the company. No gateways, no people in between, straight up to the top of the tree. And they have to have resources, that's people and money, to deliver the DP program within the company. They also have to work very closely with IT and with HR. The DPO cannot be in a department that has a conflict. So HR cannot be the mandatory DPO because they will be processing and managing people's data. They will be using and determining the use of that data. The mandatory DPO can also not be in IT because IT will be looking at the infrastructure of the data, how the data should be secured and ensuring the security of the data. So logic dictates how can they police themselves. The DPO has got to be independent. They're like your critical friend, your auditor, your trainer, your library developer, and your trusted advisor across the business. Again, you need to identify the DPO and publish their identity in all the supervisory authorities you have to report to. We know you've got to train your staff, but that training needs to be a mixture of face-to-face, online, ongoing. It can't just be a tick box, here's e-learning, get on with it, we'll see you next year, because that doesn't show that you've actually managed data protection as you move forward. I'm going to leave this in. I think there's been an awful lot of industry hype around you have to do this, otherwise you're going to get a fine. Yes, if you have totally ignored everything you should have done, you have not put anything in place, you've buried your head in the sand, yes, the regulator will take action against you. That's logical, really. But I have sat on the podium with the regulator. They work very closely with me in a lot of my networks, and they have stood up on my request and clearly stated they understand 98% of organisations in the UK will not be compliant by May. But as long as that company has hit some ticket items, have got a plan, done an audit, done some awareness training, done the data mapping, have the policies and procedures in place, and are processing the activity plan, they will look upon that understandably with not favouritism, but they will understand that you've put something in place. So if a branch falls off and there's a breach and you've done nothing, then expect a fine if it's a serious breach. If you've put everything in place, but you haven't quite finished it and there's a breach, they will take that into consideration. The regulator goes after organisations that flouts the law, that ignores the law, that hounds citizens and vulnerable people. They're there to help you as much as me as a data subject, so don't fear them, work with them. So where should you be? Well, we now know you need to identify where you are in your compliance in that programme of change. You need to assess what you're doing, how you're processing that data, how you're complying with the key elements of the law. Then you need to react accordingly and start that monitoring process. And all of that is easily achievable if you look at the approach that a privacy impact assessment brings to you, because that's a new requirement of the law. So the current status, which I thought could help you, if you are GDPR compliant, all of those boxes by the 25th of May should be green. I would gauge probably most of you will probably be, maybe if you're lucky, at the bottom of the box where retention is, possibly into security, because IT security is a business activity that you normally do. Probably don't record it, but that's something you can easily do. So I think this is a good starting point of ascertaining what you need to have in place in your compliance review. So look about the compliance review, the audit, and get an action plan in place. Look at your strategic accountabilities, responsibilities, and operational. Look if you need a mandatory DPO. Find your footprint in the sand on the current law and how far are you away to meeting the new law requirements, and get a group of people across your business that are working together to deploy and implement that program of change. Most importantly, bring in and work with your third-party suppliers, which is why GroupBC did this. It's about working in partnership to ensure compliance, and they're keen as you're keen to ensure that works both ways. Again, data mapping isn't that complicated. So starting at the top left-hand corner, your compliance review, your audit looks at the type of data. Have you function creep? Is someone doing something with the data you didn't know? Have you gone and purchased loads of websites that nobody knew? Have you purchased mailing lists that you don't know where the consent is and the integrity of the data? Again, have you actually got a retention policy? Do you understand the retention periods? Have you put a process in place for data minimization? Do you understand what a privacy impact assessment is and how to deploy that across the business? Because that's a legal requirement. That's one you've got to have in place by May. Again, data types. Is it personal or special categories of data? Is it children's data? Going into the middle of the lock, where is that data held in your electronic management systems? What are the building blocks? Is it in tune with your mobile working policy and your third-party supplier outsourcing policy? How are you retaining that data in your own infrastructure and that through third-party suppliers? Where are you holding your data security? Have you deployed and told your infrastructure internally and externally what that security regime should be? And again, where's your data across the world, and have you mitigated your risks? Here's another slide that I thought that you could take away and have as a little checklist in regards to the type of things you should be doing in regards to your data mapping and security. Transparency and accountability is paramount, and it will work if you go through this by a step-by-step process. It's nothing to fear, even if you've done nothing to date. It can still be retrievable and still be deployed in a manner that's fitting. So again, look at the current footprint, govern the controls and the processing of data. How are you protecting the life cycle of that data? So again, it's a simple IARM. If you follow that, you will absolutely meet, if not 50%, possibly 90%, depending on where you are in your journey. But you've got to project plan that out. Because if you haven't been able to comply fully by May, having a project plan and accountability plan will help you, if there is a breach, to actually identify back to the ICO or the regulator what you've been doing across your achievable milestones. Again, because privacy impact assessments is a legal requirement, I've put in some slides to help you identify the purposes that you're processing the data. Where's the data going? How is it being processed? Is it internal, external? Is it being shared? Is it being managed? What are the potential security risks and compliance risks with regards to that data? What's the impact on the individuals? Is the impact on them so great that the data processing has to stop? So what are your compliance objectives? What should data roadmap? And again, what are your legal gateways to hold and process data without affirmative consent? You will get to stage 3. Trust me, I do it every day. But it's working in a systematic process way by agreeing your processes, managing what you do strategically, project-wise, and accountability. It's about protecting your mitigation of risk to protect your consumers, your clients, your customers' data by putting them first. And it's having that reporting and risk register regime that you're probably not used to currently. So even if a branch does fall off, you have all of that in place. The ICO, your regulator, will consider that. Hopefully that's a little bit of a round robin. It's a bit hard to do it in a short period, but again, we thought it was useful to demystify some myths, but most importantly, start engaging with you on what it is that GDPR makes you stay awake at night. Thank you very much for listening.
Thank you very much for that, Paula. That was a very informative presentation. To remind everyone, they can submit questions as we go through, and we're seeing some coming through already, and we'll address in the Q&A at the end of the sessions. I would like now to hand over to Peter Brown, GroupBC's Information Security Manager, who will update us on GroupBC's GDPR preparation.
Okay. Good afternoon, everybody. I'm Peter Brown. I'm the Information Security Manager here at GroupBC, and the reason I became interested in GDPR is that as part of our sort of 27001 accreditation, and as the Information Security Manager, we have to take account of any changes in law, in regulations, and so forth. So clearly, the GDPR comes into that category, and so it kind of got our interest. So why are we here? As Paul says, what we're trying to do is enter into a partnership with our customers so that we understand where our liabilities are in terms of the data that we're actually protecting. So, for example, you would expect us to be able to keep employees, our own employees and your employees, from actually hacking into sort of the operating system behind the systems that we provide to you, and that we would have our processes and sub-processors organized in order that we could achieve that. But obviously what we can't do is we can't stop you having rogue employees and you holding information on the system we're not aware about and making that publicly available. So we're trying to enter into this dialogue, and what we're going to do is we're going to make some collateral available to you, certainly for May, in order that we might be able to help you or your DPO understand us and understand our relationship and maintain compliance. So what I want to do is just want to go through some of the work that I've actually been through. So what I'm doing is I'm treating ourselves as a sort of a typical SME. What are the steps that I've actually been through in order that we could understand whether we are or are not GDPR compliant? So I started work in the summer of 2017. I know that because I was reading the GDPR sat in my back garden with the birds singing. That was really quite nice. Because although Paula said it's a nice, gentle read, maybe for Paula, but I beg to slightly differ that because it took me about a week to get through it and annotate it. But anyway, yeah. So what did I start? I started off by having a look at the internet. What's the internet saying about this? And is this going to be important? Well, I came across lots of videos from American corporations and American legal departments advising their partners that GDPR was coming, and it was actually something really important. And the angle they were coming from is that it's now because you're selling services into the EU's coming for you. That's kind of the language they were sort of trying to propose. And they were saying things like direct marketing lists are dead. You can't do direct marketing anymore. Fear factor, fear factor, fear factor. So what I did was I then went and looked at the UK's Information Commissioner's website, which was a little bit calmer, I must say. Though at the time when I started looking, we were still waiting for lots of information to come through from the EU Working Party 29. So, for example, Jane will be aware of this. There were references to we will be providing with you standard contractual terms. So we've waited a while for those. And I think Paul was saying that there are other areas that the Information Commissioner is working on. So we took some advice from there, and I've got some links to some of the website and some of the documents that I looked at that you might find useful. So the next thing was I actually reviewed the GDPR. I think it was fair to ask anybody else to begin with to sort of say, oh, do our GDPR compliance, because I know the business quite well. What I didn't know was the GDPR quite well, so I just took my time and reviewed every paragraph the clause of the GDPR against us as a business, and I'll dive into a little bit more later. And what I did was I created a feedback document. So every time I saw something that was worthy of note, I wrote that down. So I wrote the paragraph against it, and ended up with this massive document that it had no context. It was just a bunch of things to worry about. So what I needed to do was go from that sort of uncoordinated list of activity into a coordinated list of activity. And in order to do that, what we've done is we've created a treatment plan. So we've got an action plan. So in terms of GDPR, yeah, reviewed it against every clause that I thought we needed to sort of take action on or have proof that we were compliant. So just being compliant isn't really good enough to me. I think we need to be able to say we're compliant and this is how we can demonstrate that. I think it's the information management piece coming through. So all in all, I found about 90 clauses that I thought were directly relevant to us. Some of the GDPR relates to sort of supervisory bodies and, can you prosecute through a supervisory body and ripple that up through to the EU, and how's all that going to work? That's in the same document. So obviously I was able to ignore sort of large swathes of it, but I still ended up with about 90 clauses that we needed to treat. And what we're going to do is when we've treated all of those, we're going to make that document available to people if it would help. So DPRs may or may not find that useful, and you may or not find that useful. Just as an example of what our action plan actually looked like. So in order to get that document together, our strategy plan had to take all of that uncoordinated activity, and what I was looking for was commonality. So am I saying the same thing? Have I got the same worries time after time? And I came down to about 18 things I thought boiled all of that content into terms of activity. But because we're a SaaS supplier, I didn't just analyse us against GDPR in terms of providing that information, because after all, we are an SME. So I analysed us against those 90 clauses as in the form of 4 actors. So as a data controller, So we have starter and leaver processes. We have a payroll system. We need to make sure that we're recording all of that information and holding that information for as long as possible. We are also a data controller and a processor of information. So we are a marketing organisation. So we have marketing lists, and marketing lists have been the most difficult area that we've actually looked at in order to understand whether or not we have compliance. But we also have records about customers and prospects in our CRM system, and because we're also a support organisation, our support system is called Freshdesk, and we have a whole bunch of contacts in Freshdesk as well. So we just need to understand, are we managing these content lists adequately? Then the one that probably we're most interested in today as a SaaS supplier. So your customers are holding personal data and we're processing it. So we understand that we have joint responsibility. So the kind of things we need to understand are we implementing the correct cyber defenses and so forth. But what we as an organisation don't understand is actually the level of personal and sensitive and commercially sensitive information that you hold in the system, which is kind of why we need to work with you, because we don't systematically go through the information that you store. So we don't know what's there. We know that when we first engage with it, we'll put a system down that's got nothing in it, and the only time we'll ever come across the information later on is if we're actually providing some kind of support function. And the last actor that we considered ourselves to be was as a software development house. So privacy by default can only really be provided if we understand how to securely develop software. So the treatment identified, so putting roughly into those areas, as an employer and controller. So have we got consent from all our employees to hold the data that we do? It is just having a contract of employment sufficient. What's our legal right to hold that information? And again, that comes to something else that Paul was saying. We actually need to consider that as part of a HR strategy when we've got a retention. We need to hold some of that information. What we decided to do was actually produce an information asset register. So I've assessed us as an organisation, and I don't believe that we need to appoint an official DPO. We don't systematically manage lots of sensitive information, and we're an organisation of less than 250 people, and we don't share information across sort of partner companies. So we assessed ourselves as not requiring a mandatory DPO, but I did decide that having an information asset register whereby we identify what information we're holding it, where we're holding it, how do we protect that information, have we done due diligence on the supplier, etc. So we are actually holding that information asset register, and again, subject to the right NDAs and so forth, we could make that available. We also decided that carrying out impact assessments when significant business events occurred was a good idea, and I'm really glad I had this in my slides, because Paul had two slides that said do privacy impact assessment. So one of the things that we recently had was that we changed our infrastructure as a service provider within a data center. So we carried out a privacy impact analysis of that. Our data protection policy, we need to update it. It's based on the old principles, so we just need to make sure that we change that. And also we need to introduce a data breach policy. So we're an SME. If we had a data breach, we would know about it, because our supplier would tell our systems manager and we would get to know about that. But we haven't got it written down, so we're actually introducing a data breach policy. And likewise, we're also introducing a subject access policy. So we're not expecting people to approach us a lot about the information that we're holding about them, but best we have a policy so that if someone does that, we've we've got that covered. I've got a note there that we can't charge whatever it was, the £35 in order to do that. Marketing. This was quite a difficult, and I think we started off on marketing. So we used the Information Commissioner's Office quite a lot in order to determine what our direct marketing activity should be. And what I want to do is write that activity down into a policy. So the kinds of things that we have to do is when people say that they don't want to be contacted, we actually need a contact list that says people are on this list. If we don't have a sort of a list where people identify themselves as not wanting contact, then they will be permanently added. They will be permanently being added and taken off our marketing list. So the ICO has lots of guidelines around how you should carry out direct marketing, what are the things in place that you should have, what are the third-party organisations that you should use in order to make sure that you're not contacting people who elsewhere throughout the UK have actually identified themselves as not wanting to be contacted. Profiling, the word profiling appears quite a lot. There you go, technical, it appears quite a lot in the GDPR, where we're talking about making automated decisions about people. So we've also looked at the ICO's advice as to what constitutes profiling, and we don't consider that we carry out profiling. So we're not making automated decisions that would affect whether someone gets a credit card or whether their mortgage, the mortgage rate they're given is higher, or indeed whether we're doing sort of targeted online social media. We're not doing those things. What we will do is we will understand the location of someone that we've marketed to, just in case we're providing a seminar, so within a 50-mile radius, that kind of thing. But we're treating that as not profiling. We could stand to be corrected. But in terms of GDPR, we don't consider that we are a profiling organisation. Okay. In our organisation, our sales and marketing department own our communications matrix, which basically says these are all the types of communications that we need to provide to people, and these are the circumstances under which we need to provide that information. So that goes all the way through from having a prospect who might want a pre-sales pamphlet, all the way through to if we've had a data breach, then we need to consult with the Information Commissioner. So we just need to make sure that the matrix is still accurate. And then we needed supplier clauses. Because we're all in this together, we do have processes. So we are a processor, and we use an infrastructure as a service provider, so we have sub-processors. So what we want to understand is that we have the necessary GDPR clauses in place, and Jane has been handling that for us. And if there are any questions around supplier clauses and client clauses, Jane's here in order that we can answer those. In terms of client clauses, I'll come to that in a second. Yeah, okay. So as our third actor, we are a SaaS provider, and that's largely why I think we're gathered here today. We will be providing standard customer contractual clauses. So some of you have been asking us to look at the clauses that you have. The largest set of clauses I've heard from one customer is 28 pages. But we're hoping that when we put those clauses into our contract, that we should be able to simplify that. Unfortunately, quite recently, the Crown Commercial Services have provided sort of a pro forma set of clauses that they need people to stand by whenever you're working with the Crown Commercial Services on their call-up contracts, and for us that amounts to G-Cloud. So if you're dealing with government, likely local government as well, or if you're involved in G-Cloud contracts, then you're probably going to get familiar with those standard clauses. Our SaaS platform, we do actually need to make some changes to that. I'll come to those a little bit later. But essentially, we were capturing things like your home phone number, and we had a section that could be misinterpreted as well. So we were actually after we had a screen that says, can you tell us what your contact details are, what your address is, meaning what's your business address, where can you be contacted, but it didn't actually use the word business. So it could have been construed. So it could have been construed that we were actually after people's home addresses. So what we're asking you to do, and I'll say it again when we come back to this, is to review the system, to have a look at the edit user and the preferences screens, and ask your employees to have a look there, just to make sure that we haven't captured any home phone numbers or any home addresses. So that's quite important, and I'll say that again in a couple of slides' time. Okay, so the next thing that was important to us, we need to make sure that our supply chain maintains its certification regime. The GDPR says that if you are engaging with certification programs, and then as long as those are sort of well-recognized accreditations and certifications, then you're probably doing the right thing, and that will help us, and you will be seen more favorably, I believe, if that's the case. So we need to understand whether our supply chain are 27,001, 9,001, 14,000, and the rest of it. Also, because we don't know what level of information you're holding, we do offer a very solid base system in terms of cyber security. So it's a hypervisor, it's isolated data, isolated networks, etc., etc. But you may know better than us that you actually need to beef up your cyber security in terms of, say, intrusion detection, that kind of thing. So our service providers can provide increased cyber security should we need to, but that's a decision that your DPO is going to have to make. But just to say that if you have a specification, we believe that we will be able to work with you in order to implement those additional cyber defences. We've also introduced focused privacy policies. So the privacy policy has to clearly identify that it's relevant to the bit of the system that you're in. So if you're on a website, we don't want to understand, the policy that you have there might be different to if you were editing preferences in our system. Whereas before we had sort of one quite large policy, now we have very much focused privacy policy. Important to us is we maintain our own 27001 certification, which is where this actually started. And one thing, I also want to make sure that the data handling policy that we have is actually still suitable for purpose. So you may have found that if you've tried to give us some information that you want uploaded onto the system, and you try to hand that to us in the form of, say, a CD or a dongle, we may have actually flatly refused to take that information from you. Because we need things like, if it's on a dongle, we need the information encrypted, we need the key provided elsewhere, we need you to classify the information on there, and we also need you to sign the information over to us. So I just need to make sure that the data handling policy is fit, and then we're actually following that as an organisation. And finally, in terms of the four actors, we take security seriously, and we're proud of our sort of record in terms of security, and we do have a secure development policy, and we have staff who look after that. And what was one of the particular elements of that, if people ask you about it, is the main tenet is OWASP. So OWASP are the people that are monitoring the major types of attack. So our secure development is based around being able to make sure that we are aligned against all of the OWASP, something like the top 10, and we take on all their best practices and so forth. So what can we do to help you and your DPOs? Well, what we can do is we've got our BC platform compliance features. I'll just go over to that. Okay. Yeah, so our compliance features. So there are a number of things that we are changing on the platform. And what we'll do is we'll give a document that says this is why we think our platform is GDPR compliant. But just to reiterate, at the moment there is a screen whereby we can collect a home phone number. We will be taking that away. We will no longer be able to do that. We have a screen whereby we ask for an address. It may be the case that someone has actually put their home address in there. So we would ask you to review with your members of staff that they review the details we're holding about them, or that you are in fact holding about them, in order to make sure that that information is removed. If you don't remove it, you won't actually be able to surface it in the GDPR sort of compliant release of BC that will be coming out after May. So if you are in any way relying on that information, I guess the message is don't rely on it, it won't be there. Also in terms of IP addresses, at the moment we record your IP address and you can actually surface that to you in the system. Going forward, we will still record it because we think it's valuable information to us in terms of logging for cyber defences. But what we won't do is allow you to surface that. It'll be information that an investigator would be able to get at, but it won't be surfaced. And also some of our customers have their own terms and conditions sort of when you come to log on to the system. But those terms and conditions of use don't have to have it isn't an affirmative action, so you don't actually stop people using the system. All you're doing is asking that they look at your terms and conditions. So what we'll be introducing is, as you sort of log onto the system after you're upgraded to a GDPR version, will be that you have to positively check that whether you want marketing materials from us, and you have to positively identify yourselves that you're willing to abide by the privacy policies and the acceptable use. And what we can do with your customers is incorporate the ability for you to have affirmation that people are going to abide by your terms and conditions. So you'll need to work with us if you want that to be the case. We will be contacting you in terms of changing our contracts. I think we're initially contacting by letter, and then there may be a schedule as an amendment to the standard contract. But if you need to know any more about that, then Jane is with you. We can give you a copy of our secure development policy. We can make sure you can get copies of our 27001 certification, our data handling policy. We can provide details around increased cyber security that you can take, and we'll also make sure that you can have the certifications of our hosting providers. We were particularly proud of the hosting providers that we chose. So, NGD as our primary data center is a very impressive facility. We'll give you our GDPR treatment document if you actually need it. And lastly on that is I've actually received a number of customer compliance requests from your legal teams to say I am processing those. If you continue to bring those in through our marketing organisation, I will continue to process those, and I'll get those back to you as soon as I can. But we do have a holding statement, and this webinar will hopefully help your legal team understand the sort of the timelines that we're aiming to. And almost lastly, to help, also as an organisation, if you understand who we are and where we are solely developed in the UK, and we are solely hosted in the UK. We're not aware of any cross-border data transfers that are taken by our activities, and we don't believe that our activity would be subject to the Patriot Act. So whether you think that's a positive or I would hope that would be a positive to most organisations. So just to say, these are the things that we will be providing to you. Our GDPR treatment document, so this is what we found out about ourselves and this is what we've done about it. this is how our platform is compliant with GDPR, so your DPRs may be interested in that. And then we're also going to provide this presentation. And I've also got at the end, just to quickly fly through these, there are some useful links. So these are just some links that I found useful in order to get an understanding of the subject. So if you pop through those, they all relate to major organisations, BSI, Information Commission, and so forth. But there is a lot of good advice out of there. And that's my session finished. I don't know how long that's for.
Okay, that's great. Thanks very much, Peter and Paula. And just to mention also, Peter was referring to Jane Aspel during his presentation there. I didn't introduce Jane earlier on. She is our legal counsel and is actually present with us today in this webinar. We're going to begin answering some of the questions that have been submitted. We've covered a lot today. Paula, some of the questions that have come up are particularly around your presentation, and I think they kind of allow you to maybe draw out some key points, if that's okay. So first question, what is the criteria to appoint a mandatory DPO?
The criteria would be if you're a public authority, local authority or government body, you need a mandatory DPO. Your next test is, as Pete was saying, is are you processing a volume of data? Is that processing systematic, regular, and does it identify individuals? And is that data special categories of data? And what special categories of data are is ethnicity, sexuality, trade union membership, medical information, police information, genetic information, biometric information. If you're processing that and you're doing so on a voluminous manner, and it's even if it's profiling or not, then you've met condition 1. If you're then processing that data as a core activity, so it's a core function of your organisation, then you've met condition 2. So the likelihood is you'll need a mandatory DPO. But there's lots more other tests that you need to do as part of a compliance review, and that comes into your data mapping. Have you identified the volume of data against each individual? Is it personal data? Is it special categories of data? Are you profiling? Is it systematic? Is it regular? And is that data being transferred and processed in line with their rights? So that's a sort of tiny capture, but it's quite a big process to ascertain, and it's different for every organisation.
Great. You discussed the importance of systematically working towards compliance and the effect that would have in terms of the regulator's attitude towards you. Worst case, what would result, in your opinion, in a 2% fine or a 4% fine?
Funnily, you should ask that, because we've been, I collaborate with the regulator on different networks. We have a network set up with housing providers, and we had a massive conference in London with 450 organisations attending, and this came up as a key topic. And from a regulator's point of view, they've said we cannot distinguish, determine, or even say when we'll apply a 2% or when we won't apply a 2%. It's a case-by-case basis. And the same for a 4% fine. From my experience, if you just look at some of the cases that are in the public domain, you know, if an organisation has not put proper security controls in their data centre and ensured that their supplier has done that. So this is one of the myths that I deal with, is a lot of my clients, when there's been a data issue or a data breach issue, they've gone, oh, it's the third-party supplier, it's the processor's fault that it's been hacked. And it's like, no, because you're the controller, you've outsourced that data into a hosting environment. It's your responsibility to ensure that security is being applied, pay for that security to be applied. Your hosting agent, your third-party supplier, as your critical friend, your expert, is to give you those options for you to pick from. We're bouncing around with the regulator. They've issued their guidance on breach management. They're still very unclear at the moment in regards to types of cases. So unfortunately, it's a case-by-case basis. But give you a tiny example, if you don't process a subject access request in line with the new law, it's a 2% fine. If you do not put proper controls in place and personal data is compromised or at risk, or special categories of data is compromised at risk, and you've done absolutely nothing, and there is a detrimental impact on the individual, both from money loss or from fraud or from abuse or from harassment, then that's a potential 4%.
Okay, thank you for that. One of the things that GroupBC and all of our clients have in common is that we want to win work with people that don't currently know us. Can we still market business to business?
Here's the good news and bad news. So let's just do the bad news. Under the new laws, it clearly says business-to-business marketing needs affirmative consent. And the reason why it's done that is because when you market business-to-business, you're putting the first name or last name of the individual against the end part of the email, for example. So paula.toy@righthassle.co.uk. The very fact that my name is at the beginning, that's personal data. I need to affirmatively consent to that. Is there a way of getting around that? Potentially, and I'm still working on it, so don't do this yet, is I as an employee, my employer would then write as part of our employee privacy notice that your first name and last name will be held for employment purposes, blah, blah, blah. It will also be held and used to promote the products and services of Right Hassle. It will also be used on websites, emails, marketing material, business cards, and so forth. Therefore, even though your first name and last name is your personal data, we require as part of the performance of a contract your agreement to be able to use that information. Because as an employer, how could they put me on the website if my details weren't there? How could they send out newsletters? So what we've done in Right Hassle, and we're still scoping this out, and we'll send it to the ICO for review, is splitting our activities. So if someone visits us, our clients will be told, operationally, when you engage with us as a client, we will give you legal advice, we will give you legal briefs, we will give you a legal updated bulletin on these regular bases, because that's our legal information to you. We're duty bound to do that. However, if we want to promote our products, services, ideals, events, training, then that would be marketing. We need you to positively opt in, and you need to opt in per service and then per activity. Now, that's the debate we're still having in marketing, because they're going to go, well, under each activity, we're going to have probably 5 extra tick boxes. So I'm going back to the ICO going, could we not just have a generic opt-in, and then, that they've opted into complete marketing, rather than break it down by service? We prefer per service, because some clients may want GDPR support, employment support, immigration support, commercial contract outsourcing support, but they don't want anything about agriculture. It wouldn't be relevant to them, and they don't want to hear or receive things. So it is a movable beast, and I am calling it a beast, because somebody in the European Union did not clock, when they put business to business, the complexity they would cause. And the DMA has actually issued out a call to action for this to be changed and for business to business not to be incorporated. The ICO currently has not commented, but they have issued links to the marketing code, GDPR marketing, and a marketing checklist. So I can send those over to GroupBC, and maybe they could put those on those links as well.
They may be in there. Great idea. What does the regulator mean by demonstrating compliance with security?
So what you would require to do, they haven't determined or defined it, but when we've been discussing it and when they've been on conferences with us, we've been debating what that is with them. So it would be your information security policy, acceptable use policy. It'll be, your starter and leaver process. It'll be a strategy that everything sits under. It'll be your penetration testing. Everything that Pete was basically saying with regards to looking at the infrastructure of the security, both from the data coming in, the data coming out electronically, but also data that you're holding in a paper-based form, having a clear desk policy, having a visitor policy. So, for example, today at GroupBC, I had to sign in. I'm only allowed to go to one location. I can't go wandering around the offices. I've been told I'm not allowed to wander around the offices because there might be commercially sensitive data or client data out. I'm only allowed to go to certain zones. I've been told what I can do, can't do. And, you know, those can be easily implemented by a little poster when I sign in that you're asked to read. Sign in, here's your badge. And by accepting that, tick here that you've accepted that we're going to hold your data because you're a visitor to the building. We've now got your name. We've got your car reg. You're now holding my personal data. I can now go to GroupBC and put in a subject access request, requesting that data from the visitors book. They would come back to me and go, I'm ever so sorry, Paula, but yes, we'd be happy to supply you with that data. However, our visitor book is destroyed on this retention period. But here is an extract of when you signed in. Bob's your uncle. So it's not just IT security, it's your whole infrastructure security. Policies, procedures, strategies, accreditations, certificates, and audits.
Okay, great. It sounds very much like everyone wants definitive answers to something that's evolving and will continue to evolve and maybe doesn't lend itself to definitive answers. But if I'm in an organization and I haven't started my journey towards compliance, what are the key things I need to do now?
Right, number one, don't panic. Okay? I'm a privacy professional. Jane, you know, the amount of, I don't know how many emails you guys are getting on GDPR compliance. I do not manage my email box anymore because I'm fed up of having these, you will get fined, this is what's going to happen, you've got this. Yes, we have a number of days, calendar days, to get to the 25th of May. But again, which is why I designed the presentation as I did. If you've done absolutely nothing, stage one, do a compliance review. Me and Jane, we've been discussing what we do is we basically can have a full compliance review in 5 days, come in, we absolutely get it right under, figure out what's going on, do a data map, do a report, create an action plan, Bob's your uncle. To actually, an advisory visit will probably be sufficient in some cases where we do that and we give you a questionnaire and we build that action plan based on those. So you actually build those processes. But if you go back to the slides, when you come back and request them, is you will actually see that if you follow my step-to-step circle of compliance, you'll be proficient. So compliance audit, review, action plan, project plan, steering group, data mapping, governance controls, security of data, and if you look at those key areas on my circle of change, that should give you a good starting point.
Brilliant, perfect. Well, I think that is all of the questions that have been raised, answered. I'd just like to take this opportunity to bring the webinar to a close. So thank you very much, Peter and Paula, for those very informative presentations, and Jane for your ongoing guidance in the background. And thank you, everybody, for attending today's webinar, GroupBC supporting you with GDPR compliance.